Back in May, after waves of protesters converged on the Supreme Court in response to the leak of the draft opinion that would overturn Roe v. Wade, a black fence appeared around the court's perimeter. The the black fence was 8 feet tall, and it was deemed unscalable by the authorities. But it offered an eerie echo of how the court's neighbor on Capitol Hill had looked behind barricades that were erected after the Klan insurrection of January 6th of 2021. What happened at the Capitol on that January day was an attempted coup. Now, what happened at the Supreme Court in June of 2022 was a power grab of a different sort, driving the law far to the right in service of an agenda that most Americans don't share. Now, now in June of 2022, it caught many Americans by surprise, but it shouldn't have. The majority votes that erased the right to abortion, that puts a constitutional effort to keep guns off the streets, um, also, and it put a constitutional stranglehold on states and cities' efforts to keep guns off the streets, and it further tightened religion's grip um, on civil society, and that cast an ominous shadow over the policy making up apparatus of the modern federal government were the products of a project that goes back decades, and one that unfolded in the full view of anyone who had bothered to even keep track and bothered to watch. The decisions that the term were the culmination of the single-minded pursuit of a goal that united cultural conservatives, deregulatory free marketeers, anti-abortion zealots, affirmative action opponents, and all the other disparate elements of the political right in one common aspiration, the capture of the Supreme Court. And that aim made perfect sense, even though, if you really think about it, it doesn't really make sense at all. Although, in theory, many of the objectives that were sought by this coalition of convenience should have been achievable through politics, popular will stood in that way. The efforts to overturn Roe v. Wade by amending the Constitution had failed spectacularly, and public support for the right to abortion had in fact increased immediately following the court's 1973 ruling, and it has increased even more now following Roe's overturning and Dobbs vs. Jackson Women's Health Organization. There was a little that conservatives could do to make their agenda more appealing at the ballot box, but that meant getting the court was not simply the obvious choice, it was the only choice that they had. And this is a goal that animated the conservative movement, first in defeat and then in triumph. Basically, they think they triumphed. The conservative movement believed that they triumphed 4 months into Trump's administration when the Senate confirmed Neil Gorsuch to the Supreme Court's vacancy that was previously held, and was previously unquestioned, and previously unquestioned norms had been present. It should have been President Barack Obama's to fill, but the Republicans did everything they could to block his Supreme Court pick. A phrase began to make its way around Washington in the early Trump period, and it was shared among mainstream Republicans who were growing anxious about the chaos emanating from the White House. "We got Gorsuch," they said to one another, sometimes shortening the phrase to a kind of code. But Gorsuch, it served as a reminder that although the new squatter or president was making them nervous, Senator Moscow Mitch's strategy had kept the real prize in safe hands. Bringing the country again in June of 2022 took more than Gorsuch. Of course, it required Justice Anthony Kennedy's replacement by appointing the rapist Brett Kavanaugh and Amy Coney Barrett's confirmation to Justice Ruth Bader Ginsburg's seat on the eve of the 2020 election, another norm-shattering Moscow Mitch feat. But although getting Gorsuch wasn't the end, it was not the beginning either. On July 1st of 1987, President Ronald Reagan nominated Robert Bork to the Supreme Court. Now, this man Bork was picked to replace Lewis Powell Jr., and Lewis Powell was the swing justice of his time, the one whose vote went up to make the difference. Now, Lewis Powell was nominated by Richard Nixon. Now, Powell had nonetheless provided a fifth vote to uphold affirmative action in the Bakke case back in '78, and he remained a strong supporter of the right to abortion, even as the court was then drifting away from Roe v. Wade. Now, Bork was a former law professor and a prominent conservative intellectual, and he had famously opposed the Civil Rights Act of 1964, and he denounced the court's recognition of a right to privacy as legitimate. Now, As Paul's replacement, he would have been in a position to transform the constitutional landscape. The Republican Party had lost the Senate in the 1986 midterm elections, and the Reagan administration was beset by the Iran-Contra scandal, and it was running out of time to accomplish its domestic goals. With this nomination, major policy areas hung in the balance: civil rights, reproductive rights, including abortion, and fundamental questions of how to interpret the Constitution. Now, a Supreme Court seat could bestow such power on an individual occupant, and it rests on a yet deeper question: how did the Supreme Court itself acquire so much power over the lives of many Americans? The answer to this is to a surprising degree, is a 20th century story. Let's go back to 1925. Congress gave the court the power to select the cases it wanted to decide, instead of simply resolving disputes as they happened to come along. Before then, it remains true today, in the Federal Circuit Courts of Appeals, the justices didn't control their own docket. The power to choose, a power that Congress expanded further to near total in the mid-1980s, transformed the court from a solver of disputes between parties to a shaper, not only of its own agenda, but in many ways in the country's as well. It became a lawgiver rather than a dispute solver. Now, decades later, the court emerged from the crisis of the New Deal with more power than ever fucking before, and it reached a tacit understanding with the American public. You give us all this great power, and in return, we will give you predictability, stability, and ultimately any fucking thing that you want. A court with Justice Robert Bork would be poised to break this promise. The confirmation battle that consumed the summer and fall of 1987 was so fucking titanic that it is so often wrongly remembered as a one-off, an event in American political history that began and ended with the single overachieving Supreme Court nomination. Now, conservatives' efforts to recapture the court had begun early with Richard Nixon, but it ran against the Warren Court, and it filled 4 Supreme Court vacancies. His most conservative nominee, William Rehnquist, had survived a heated confirmation battle of his own in 1986, and when Ronald Reagan named him Chief Justice, the sight of Rehnquist in the court's center chair had fueled Democrats' determination to block anything that Bork tried to pass. The confirmation hearing, presided over by the then Senator Joe Biden, the Judiciary Committee chair, had lasted a week. Had lasted a week as Stop Bork ads filled the airwaves. The country had never seen anything like it. But Bork made clear his disdain for the senators, and he seemed to revel in his opponent's effort to define him as out of the mainstream. The nomination went down to bipartisan defeat, receiving only 42 votes in favor. Now, Anthony Kennedy's eventual confirmation to the seat by a vote of 97-0 reflected both the Senate's exhaustion and its relief at the calming contrast to the new nominee presented. Now, Bork's rigid originalism was not to Kennedy's taste, but rather the constitutional framers had made a covenant with the future. Now Kennedy said during his hearing, meaning that constitutional interpretation was not to be bound by the views of the 18th century. Now, it was Kennedy, not Bork, defined the mainstream. Jubilant progressives felt safe in regarding the Bork battle as over and in proclaiming that they had won. Indeed, for the next 30 years, Kennedy's vote was often essential to holding back the forces of reaction and to moving the law forward. He was one of the 5 justices who reaffirmed the then embattled right to abortion and Planned Parenthood versus Casey in 1992. Now, all 5 justices in the Casey majority were Republican appointees, a measure of how the world has changed since. Kennedy wrote the series of the LGBTQ rights majority opinions leading up to and including Obergefell versus Hodges, which is the 2015 decision that recognized the constitutional right to same-sex marriage. It's an often quoted quip by a prominent Supreme Court practitioner and blogger, Tom Goldstein, who attested to Kennedy's pivotal role. It's just as Kennedy's role now, and we just fucking live in it. It was a 2012 Time magazine cover that declared Kennedy the decider. It might have been Kennedy's world, but it wasn't the world Reagan and conservatives had envisioned, or which they and their spiritual and literal heirs ever acquiesced to. This was hardly surprising. Bork's opponents may have fooled themselves into thinking that by defeating the man, that they had defeated the idea of reframing the constitutional narrative. Now, the Bork battle had just went underground, and to be carried on not only by its grizzled veterans. Now Bork passed away in 2012 at the age of 85, but a generation of activists barely old enough to remember the initial round Leonard Leo, the mastermind behind the Federalist Society and engineer of its grip on Republican judicial selections, had graduated had graduated from college a month before Bork's nomination. Kerry Severino, the head of the Judicial Crisis Network, and formerly the Concord Fund, it was a major recipient and dispenser of the right-wing dark money that spent millions in support of Amy Coney Barrett's confirmation, was only in elementary school at that time. Now, presidents pick Supreme Court nominees for many reasons. Ronald Reagan chose Sandra Day O'Connor as his first nominee to fill a campaign pledge to name a woman. Now, as a candidate, Joe Biden had promised to name a black woman, and he chose Ketanji Brown Jackson. Now, clearly, ideological compatibility matters. The justices who voted to overturn the right to abortion reflected something more particular. They were chosen for this specific task. Reagan ran in 1980 on the Republican Party platform that pledged to work for the appointment of judges at all levels of the judiciary who respected traditional family values and the sanctity of innocent human life. And every Republican presidential candidate since then has run on a similarly worded platform. Now, the only exception was Donald Trump's re-election campaign in 2020, when the Republican National Convention when the Republican Party has no platform. The party's only platform was Trump being himself. During the 2016 campaign, Trump said that if he got the chance to make Supreme Court appointments, Roe would be overturned automatically. Of the 7 justices appointed by Republican President since Reagan, only David Souter, who was named by President George H.W. Bush, had failed to deliver. Now, Souter had retired in 2009, and he was part of the five justice Casey majority. Now, by contrast, Bush's other nominee, Clarence Thomas, who is now the court's longest-serving member, has proved a banner-waving success. I don't know if you would call him that. Not only has he spent his 3 decades in the court in pursuit of Roe's overruling, but his concurring opinion in Dobbs had added revisiting the court's precedents on same-sex marriage and even on birth control to the court's to-do list. Hold on a second here. Samuel Alito, who's a nominee of the second President Bush, is also a success by these standards, and predictably so. His confirmation hearing brought to light his 1985 application for a position in the Reagan Justice Department. He says, "I personally believe very strongly that the ambitious young job seeker wrote that the Constitution does not protect the right to an abortion." Chief Justice John Roberts, who was President George W. Bush's other appointment, did not join Alito's opinion on Dobbs. Now, Roberts would have gutted Roe and Casey without overturning them explicitly. But add the 3 Trump judges, add the Trump 3 to Thomas, Roberts, and Alito, all 6 not only by coincidence raised in the Catholic Church, a convenient proxy for the "will you promise to overturn Roe" question no president could ask directly, and we have the supermajority that is now redefining the constitutional landscape. And not to Americans' liking, but polls conducted while Dobbs was pending, showed that Americans wanted to retain a right to abortion by a margin of nearly 2-1. Of course, the midterm election more than bore that out. Now, the right to abortion prevailed in all 5 states where the question explicitly was on the ballot, and exit polls showed that Dobbs was a boon to Democrats throughout the country. At least one justice has openly expressed her concern. In a notable series of pointed remarks since midsummer, Justice Elena Kagan has sounded the alarm. If over time the court loses all connection with the public and the public sentiment, this is a dangerous thing for democracy. She had said this at a conference of federal judges in Montana. Kagan is a dissenter in Dobbs, but she did not explicitly mention the decision, but the reference was unmistakable. Scholars agree, warning that the gulf that Dobbs opened between the public and the court, and the majority's blatant disregard of public sentiment presents a serious threat to the court's legitimacy. Indeed, the Dobbs decision may be the most legitimacy-threatening decision since the 1930s. James O. Gibson, who's a political scientist at Washington University in St. Louis, and a prominent scholar of the court's relationship to the public, had wrote this in an unpublished paper that he posted on an academic website. Perhaps this is what happens behind the this is what's behind the caution that Roberts displayed in refusing to join Alito's majority. Alito wore his disregard for the consequences of the court's action like a badge of honor, and he kept his opinion with words both arrogant and disingenuous. We do not pretend to know how our political system or society will respond to the basically, we do not pretend to know how our political system or society will respond to today's decision in overturning Roe and Casey. And even if we could foresee what would happen, we would have no authority to let that knowledge influence our decision. The backlash the backlash basically is predictable. The current court is sharply to the right of the public opinion. According to a 10-year study recently published by the National Academy of Sciences, a Gallup poll from July showed a startling polarization head following Dobbs. Although Republicans and Democrats have been roughly aligned in their views of the court as recently as August of 2020, with at least two-thirds of both groups indicating approval, the Republican confidence in the Supreme Court had soared 29 percentage points to 74 points, or to 74%, while Democratic approval plunged 23 to 13, the lowest rating Gallup has ever measured, and the partisan gap is the biggest on fucking record. Now, a Pew Research Center poll in August had revealed an intriguing generation gap in attitudes toward the court. Across all demographic categories, like sex, race, education, the single biggest predictor of a negative opinion was youth. 63% of those ages 18 to 29 held an unfavorable view of the court, while most of those ages 50 and older had retained their positive position. Now, although the Pew researchers did not offer an explanation for this result, it could be that the memory of the court sitting benignly above the political fray still carries weight with older Americans lacking such a memory. A cynical younger generation only knows what it sees. Alito may not agree or care, but the depth of disenchantment revealed in 3 recent polls represents a crisis for the Supreme Court. Chief Justice Roberts knows this, certainly, but his clumsy effort to address the problem in remarks to a conference of federal judges in September has, if anything, underscored the court's disconnection from the world it is refashioning. Simply because people disagree with an opinion is not just a basis for criticizing the legitimacy of the court, the Chief Justice told the judges. Now, the comment had a puzzling emphasis. People aren't criticizing the court's legitimacy, they are criticizing the court's behavior. The behavior that has led to a loss of legitimacy. The connection is casual, as Justice Kagan observed in remarks at Temple Emmanuel EI in New York in September. Now, judges, she said, undermine the legitimacy when they don't act so much like the courts, and when they don't do things that are recognizably law, and when they instead stray into places where it looks like they're an extension of the political process, or where they're imposing their own personal preferences. Now, Roberts was also wrong in a more fundamental sense. It's not simply that the public is unhappy with the court's decision, and even though that's what the polls show, but something deeper is going on that eludes even a well-crafted survey. Something that may be the most important thing of all. It is a growing sense that in all its action in the past term, the current majority is abusing its power. It has broken the court's connection with the American public, reneging on the Tackett deal in the court that was made decades earlier. Now, the justices took up the case that became Dobbs because the majority was determined to change the law of abortion for the whole country, and come what may, the court has great power, but it seems to have lost any sense of the great responsibility that it should have. What happens if the country decides that the court is deploying its power irresponsibly or even illegitimately? There is no modern template for such a scenario, and that's why the crisis for the court is also a crisis for political science about the court, a fact that would be a merely professional concern were it not so illuminating of the full dimension of what has occurred. For half a century, a key text for scholars on the relationship between the Supreme Court and the public has been an article by the Yale political scientist Robert Dole titled "Decision Making in a Democracy." The Supreme Court has a national policy maker. In this short article, only 17 pages, published in 1957, at the height of concern over the Warren Court's activism on civil rights and criminal justice, Dole had pointed out that the court had tended over time to align itself with the national consensus on major issues. The court operates to confer legitimacy, he argued, not simply on the particular and parochial policies of the dominant political alliance, but upon the basic patterns of behavior that was required for an operation of democracy. Now, building off of Dole's work, modern scholars have emphasized the diffuse legitimacy that protects the court even when many people disagree with its many decisions. Recent experience seems to bear this out. Polling indicated that even Bush versus Gore, the much disputed decision that resolved the 2000 presidential election, did not do any lasting damage to the court. Now, Gibson, who is the Washington University professor, is a prominent exponent of the widely accepted positivity theory, and that it holds basically that people tend to accept Supreme Court decisions with which they disagree because those decisions are enveloped in the symbols of judicial authority, as Gibson puts it in his new article. Now this time it's different. Dobbs has punctured the diffuse support. His article, Gibson's article, has the tone of a sad mea culpa. In general, virtually all the empirical evidence that we adduce in this paper runs contrary to existing research on the breadth and depth of the court's institutional legitimacy, noting that he and his colleagues have long argued that Supreme Court's legitimacy is obdurate. Difficult indeed to change in the short term, he now concludes that in at least some circumstances, he and others may be wrong. It's not that the political scientists have been negligent in all these years. It's that a new reality has overtaken the old assumptions. Dahl's assurance that the Supreme Court would never stray too far from the public mood was based in large part on his observation that with an average 2 Supreme Court appointment in a presidential term, the court would reflect the temper of the times throughout the regular infusion of new justices. Now, the judicial confirmation as a blood sport was not in that simpler age part of the calculus. President Dwight Eisenhower had placed both Earl Warren and William Brennan on the court as recent appointments to fill sudden vacancies. It's a maneuver that would have been unthinkable for President Obama to try with Merrick Garland after Justice Antonin Scalia's death in February of 2016. Now, Brennan's appointment came less than a month before the 1956 presidential election, but both he and Warren sat on the court for months before being confirmed by the Senate once the president got around to submitting the formal nominations. Now, a political scientist would have been farsighted indeed to anticipate what would happen to the Supreme Court going from the years of 2017 to 2020. Now the squatter lost a popular vote would manage to lock in a conservative supermajority with 3 appointments. All of them confirmed by the narrowest of margins following the Republicans' abolition of the filibuster for the Supreme Court's confirmation. Now, the senators from states that collectively contain less than half the country's population, it's no fucking wonder that theory no longer fits reality. Robert Dahl's reliance on the basic patterns of behavior required for the operation of a democracy is of little use when the patterns have been shattered and democracy itself seems so fucking fragile. Now, given the problematic circumstances of its acquisition of power, the new supermajority might perhaps have shown a little humility, or at least a diffidence before driving the court off a cliff. Not so many years ago, the court knew how to stop short. Chief Justice Roberts' predecessor, William Rehnquist, offers an example, a conservative firebrand for much of his 33-year Supreme Court tenure. The justice whom liberals most loved to hate, they moderated his tone and reined in his ambitions late in his time as Chief Justice. In the 2004 majority opinion, for example, Rehnquist called for play in the joints between the First Amendment's 2 religion clauses, basically, finding that neither the Establishment Clause nor the Free Exercise Clause provided the sole answer to the question of government subsidy of tuition for religious study. The divinity students seeking the subsidy lost that case. Surely it would have won it under the analysis that Chief Justice John Roberts had used in another religious tuition case in June. In which play in the joints was consigned to history, and the Free Exercise Clause scored a complete triumph. In 2003, Rehnquist effectively called a halt to his federalism revolution, in which the court had immunized state governments against having to follow the important federal anti-discrimination laws when it came to their own employees. That free pass for the states ended. The court declared with the Family and Medical Leave Act, which Rehnquist deemed to an important weapon against employment based on sex discrimination that Congress had the authority to make binding for state employers. And had the march of the state immunity decisions continued unabated, Congress's power to enforce the 14th Amendment's guarantee of equal protection might have well been severely curtailed for Rehnquist, and that was a step too far. The one justice who remains from the Rehnquist court, Clarence Thomas, dissented in that case. He would have gone the distance then, and presumably still would. Might any others in today's conservative majority refrain, for example, from dismantling what remains of the Voting Rights Act in the Alabama case the court had heard in October? Or basically decide against embracing the newly mentioned independent state legislator theory. In a case to be argued in December, that would disable state Supreme Courts from reviving or reviewing the state legislators' rules for conducting the federal elections, and I'm including how presidential electors are chosen. Now, these are cases with the huge potential to further weaken the support structures of a fragile democracy, and one would require overturning a precedent that has guided application of the Voting Rights Act for nearly 40 fucking years by ensuring that when it comes to redistricting, a minority community of sufficient size, cohesion, and compactness must receive a fair opportunity to elect representatives of its own preferred choice. Now, the other would take the courts into a completely new territory, pure politics without a precedent in sight. The justices who make up the majority have nothing in their way. That is the nature of being that's the nature of being a supermajority and control the most powerful courts in the world. These justices, or more accurately, the forces that propelled them to the courts, have been waiting a long time for this fucking moment. If the country decides that it's seen enough overreach from the court, the individual justices insulated by life tenure from the consequences of playing politics will not pay the price. The Supreme Court itself will, and the price may be incalculable. So So what I want to know is what the fuck happened to the Supreme Court. Basically, I can't even really say what the fuck happened to them. So, but if you like the video, give the video a like and subscribe to my channel, RBW King. You can also hit the notification bell so that you'll be notified when a new video comes out. And if you want to support my work even further, you can donate to my Patreon link, which you can find in the About section of YouTube, and for just a little as a few bucks a month, your donation can help go a long way, and thanks for listening.